Most families think the biggest threat to a parent's home is rising nursing home costs. It isn't. The real shock comes later, when the family realizes the state can legally step in ahead of the children, ahead of the heirs, and sometimes even ahead of the surviving spouse to recover every dollar spent on long-term care. And in some states, that process starts before the parent has even passed away. That's why thousands of families are now scrambling to understand a rule they never knew existed until it was already too late. Because once Medicaid enters the picture, the family home is no longer protected the way most people assume it is. And the 5 states in this video have built some of the most aggressive estate recovery systems in the country. The program behind all of this is called Medicaid Estate Recovery. Most people have never heard of it until a nursing facility becomes part of the conversation, but federal law requires every state to operate some version of it. The rule dates back to 1993, when Congress passed the Omnibus Budget Reconciliation Act. Before that law, states could choose whether they wanted to recover long-term care costs from a recipient's estate after death. After 1993, recovery became mandatory. That changed everything. Under federal law, if a Medicaid recipient receives long-term care services after age 55, the state is required to seek reimbursement from that person's estate after death. But the part most families never realize is that federal law gave states enormous flexibility in deciding what counts as an estate in the first place. And that single definition is what separates ordinary states from the aggressive ones. Some states only recover assets that pass through probate court. Others reach much further. They target jointly owned property, life estates, transfer on death deeds, certain trusts, and in some cases, even assets connected to a surviving spouse years after the original Medicaid recipient has already passed away. That is why 2 families with nearly identical finances can have completely different outcomes depending entirely on which state they live in. The first aggressive state on the list is Massachusetts, and Massachusetts is feared for one reason above all others: the lifetime lien. Most people assume Medicaid recovery happens after death. In Massachusetts, that assumption can be dangerously wrong. Through the Mass Health program, the state can place a lien on a senior's home while the senior is still alive if they enter a nursing facility and are determined to be permanently institutionalized. That means the state doesn't wait for probate. It doesn't wait for inheritance proceedings. The claim can begin during the senior's lifetime, and once that lien is attached, the situation changes immediately. The family can no longer freely sell the property. Refinancing becomes difficult or impossible without addressing the lien. Transferring ownership becomes heavily restricted. Meanwhile, the lien continues growing every single month the senior remains in care. And in Massachusetts, nursing home costs are staggering. Many facilities charge between $14,000 and $18,000 per month. That means a 1-year stay can add roughly $170,000 to the state's claim. 2 years can push the lien beyond $350,000. In many middle-class communities, that is enough to consume most or all of the home's equity. What makes the situation even more devastating is how quietly it happens. The lien is usually recorded with the county registry of deeds. Families often receive no dramatic warning. Adult children are rarely notified directly. Many discover the lien months later during a refinance attempt, a home sale, or after an attorney performs a title search following the parent's death. And there is another complication families routinely misunderstand. A lot of people believe they can simply transfer the home to their children before applying for Medicaid. But Massachusetts aggressively enforces the 5-year look-back rule. Transfers made within 5 years of a Medicaid application can trigger a penalty period during which Medicaid refuses to pay for care. That creates an impossible financial situation for many families because the nursing home still expects payment during that penalty period. At Massachusetts rates, even a short uncovered period can financially devastate a household. That is why many families turn to irrevocable Medicaid asset protection trusts years before any long-term care event occurs. If structured correctly and funded early enough, the home may eventually fall outside Medicaid eligibility calculations and avoid the lifetime lien entirely. But timing is everything. The deed must actually be transferred into the trust, and the full 5-year clock must run uninterrupted. The cruel part is that families often discover the problem years later during a title search. Everything appears fine until the property is sold or transferred. Then the state's interest suddenly appears. To avoid this, many Iowa families now rely on transfer on death deeds rather than joint ownership. These deeds allow the property to pass automatically at death without creating the same joint ownership complications during life. But even that tool has risks. Filing errors, recording mistakes, or conflicts with existing wills can invalidate the protection completely, and Iowa's rules have evolved repeatedly over time, which creates another problem. Families who relied on advice from 20 years ago may now be operating under outdated assumptions. New York presents a different kind of danger altogether. New York is famous for Medicaid asset protection trusts. Entire industries have grown around them, but New York is also where improperly drafted trusts fail with devastating consequences. The biggest misunderstanding involves timing. Many families believe the 5-year look-back period begins when the trust is created. It does not. The clock begins when assets are actually transferred into the trust. That difference destroys planning strategies all the time. A family might sign trust paperwork in 2020, but fail to retitle the home until 2022. In that case, the look-back period does not expire until 2027. If long-term care becomes necessary before then, Medicaid may treat the transfer as disqualifying, and New York nursing home costs are among the highest in the nation. Private pay rates often range from $16,000 to $22,000 per month. Savings can disappear shockingly fast. The trust itself must also be drafted with extreme precision. Certain retained powers or ownership rights can accidentally cause the trust assets to remain countable for Medicaid purposes. Historically, because Florida Medicaid recovery has focused heavily on probate estates, properly structured ladybird deeds have provided significant protection. But once again, execution matters. Generic online forms often fail Florida's technical recording requirements, and timing matters just as much. The deed must be signed while the senior still clearly possesses legal capacity. Once cognitive decline or nursing facility placement enters the picture, opportunities narrow dramatically, and that leads to the biggest lesson across all 5 states. Families wait too long. They assume a will is enough. They assume adding children to the deed is enough. They assume verbal family agreements somehow matter against Medicaid recovery statutes. They do not. The state's recovery rights are backed by federal law, state statutes, administrative procedures, and court systems designed to enforce them. But there is another side to this story too. Planning can work when it happens early enough. Irrevocable trusts, ladybird deeds, transfer on death deeds, caretaker child exemptions, life estate arrangements, and coordinated beneficiary planning can all help preserve assets under the right circumstances. The key is timing. Almost every meaningful strategy depends on acting before a long-term care crisis begins and before the 5-year look-back period becomes a problem. That is why elder law attorneys constantly repeat the same warning. The best Medicaid planning happens while everyone still believes they have plenty of time. Because once the nursing facility admission happens, many of the strongest tools disappear, and that is the part families rarely hear until it is already too late. The government's right to recover is not hidden, it is written directly into federal law. What catches families off guard is how aggressively some states apply that power, how technical the rules become, and how easily ordinary assumptions about inheritance fall apart once Medicaid enters the equation. The question is not whether estate recovery exists. The question is whether the family acted early enough to keep the home outside the estate before recovery ever began.